The U.S. Supreme Court ruled in favor of the Little Sisters of the Poor this week, upholding their religious objection to the Obamacare contraceptive mandate. Will this be the final word on their case? Here with analysis is attorney and spokesman for the Judicial Crisis Network, Gayle Trotter. Gayle, as I mentioned, the U.S. Supreme Court on Wednesday ruled 7-2 in favor of the Little Sisters of the Poor. This is a decade-long fight against the Obama-era contraceptive mandate, which obliges employers to provide cost-free contraceptives, sterilizations, and emergency birth control in employee health care plans under the Affordable Care Act. Now, in 2017, the Trump administration granted a religious and moral exemption to the mandate for the sisters and other objecting groups, but then states, Pennsylvania, California, and others, filed lawsuits saying the burden of providing that coverage was being shifted onto the states, claiming that the administration violated the Administrative Procedure Act. In the majority opinion, Justice Clarence Thomas ruled that the Trump administration's challenged the rulemaking was above board and hailed the work of the Little Sisters of the Poor. He wrote this: "For over 150 years, the Little Sisters have engaged in faithful service and sacrifice, motivated by religious calling or a religious calling to surrender all for the sake of their brother. But for the past 7 years, they, like many other religious objectors who have participated in the litigation and rulemakings leading up to today's decision, have had to fight for the ability to continue in their noble work without violating their sincerely held religious beliefs. We hold today that the departments had the statutory authority to craft that exemption, as well as the contemporaneously issued moral exemption. We further hold that the rules promulgating these exemptions are free from procedural defects." Now, all that's a big way to say the sisters are now free to not pay for those contraceptives. What does this mean to other religious organizations, Gayle?
Well, this is a huge religious liberty win, not only for the Little Sisters of the Poor, as you noted, but also for all Americans, not just the ones who would also be subject to this exemption and not have to violate their conscience, violate their religious liberty in order to continue serving their missions, but for all Americans, because our religious liberty undergirds so many of the important things that go on in our culture.
Gayle, Justice Kagan filed an opinion joined by Justice Breyer, in which she agreed with the result that the majority came to, but not with its reasoning. Kagan argues Pennsylvania could further challenge the religious exemption as arbitrary and capricious in lower courts. Is this fight over?
No, I predict that it's not over. The battle has been won in this case, but the war rages on. And it is excellent that we saw that the Supreme Court came out with a 7-2 decision. You only had Ruth Bader Ginsburg and Sonia Sotomayor, who were dissenters in this case. But because it wasn't decided on constitutional grounds or on congressional statutory grounds referring to the Religious Freedom Restoration Act, then it is something that can continue to go on. And you're going to continue to see these efforts by the left to attack and erode religious liberty. That's not going to stop.
Gayle, I hate to disagree, Gayle. I mean, I agree with you on that point, but I disagree that this is a victory. This, to my eyes, is a very narrow ruling. And in a statement put out Wednesday, Democratic presidential candidate Joe Biden had this to say about the Little Sisters of the Poor case: "As disappointing as the Supreme Court's ruling is, there is a clear path to fixing it. Electing a new president who will end Donald Trump's ceaseless attempts to gut every aspect of the Affordable Care Act. If I'm elected, I will restore the Obama-Biden policy that existed before the Hobby Lobby ruling." Explain to people what that means, what he's essentially saying there.
Well, the fact that this is even a case is a travesty, because this is just a gratuitous attack on people of faith. And the Hobby Lobby case referred to in Joe Biden's statement is where the Supreme Court said that there were conscience-based exemptions were okay under the Religious Freedom Restoration Act. And I think it's very important to look at what Justice Alito said in his concurring opinion. He would have ruled in favor of the Little Sisters and similarly situated employers by saying that not allowing them to have this exemption would be a violation of the Religious Freedom Restoration Act. And we saw the response from Justice Ruth Bader Ginsburg essentially saying that this is taking religious freedom to the nth degree. And there's this point in Justice Alito's opinion, his concurring opinion, where he says it's almost like they're trying to establish a constitutional right to contraception. And so it goes back to this idea that it's not enough for the government to provide this. They want to make the nuns and people who object to this complicit, to violate their faith, or to pay heavy fines, or to not be able to give their employees health insurance. And the whole justification behind Obamacare was to increase health insurance for Americans. And not a single woman was identified in this litigation who was not able to access contraception. So it's a problem without a problem.
Well, Gayle, the problem here is you have a very narrow decision, and despite repeated Supreme Court rulings, what we've come to is if a new administration comes in tomorrow, they can eradicate this with a stroke of the pen, and the nuns will have to provide contraceptives again. That's basically what the court is saying here, which blows my mind after all they've been through and years and years and years of watching this case. I have to move on. The Supreme Court sided with Catholic schools in an employment lawsuit. The High Court said that religious school teachers who perform a religious role, even if they're not ordained, and even if religious instruction makes up a small part of their overall responsibilities, are subject to what's called the ministerial exemption. Now that basically cuts them out, that exception cuts them out of civil rights protections afforded to other employees. How broad is that exemption? And does it apply to math teachers or science teachers?
Well, that's a great question, because that is exactly where the contradiction is and the disagreement is. Because how far should the Supreme Court go in determining what religious organizations can do in determining who they want to teach and inculcate the faith? And this is something that the Supreme Court should not get involved in. It should very much generously respect the First Amendment rights of these religious schools, and to also make sure that their statutory rights under congressional law is respected as well. So you don't want the Supreme Court making the hiring decisions for religious institutions and deciding whether or not a particular role is really what is necessary for the inculcation of religious faith. And here is yet another example, also with the Espinoza case that was decided last week, where the Supreme Court is coming down on this side of religious liberty. And I will tell you that all the 4 justices appointed by the last Republican presidents have all been firm in supporting religious liberty. And that is something vitally important that needs to be carried forward in future Supreme Court decisions as well.
Gayle, I have 30 seconds. Where do these 2 rulings that we've just discussed, where do they fit alongside last month's ruling that the Civil Rights Act of 1964 prohibits employment discrimination because of sex, protecting LGBT employees?
Right. And this is seen as a corollary to that, where we're going to continue to see litigation of plaintiffs trying to carve and erode religious liberty, even in situations where it's clearly part of free exercise of religion. And I think Justice Thomas has gone at great lengths to explain how we have gotten the Establishment Clause all confused in the last few decades, and that bleeds over into the Supreme Court's jurisprudence on the Free Exercise Clause. And so you're going to continue to see these issues play out in the lower courts. And that's why it's so great that President Trump has honored his commitment to make sure that the federal bench has independent, faithful judges who are faithful to the Constitution, because these issues are not going away, and they're going to continue to be litigated in the federal courts and eventually percolate up to the Supreme Court as well.
Gayle Trotter, the Judicial Crisis Network, thank you for being with us.
Great to be with you, Raymond.